As many of you know, my name is Shayne Epstein. I'm an immigration attorney with 22 years of experience practicing employment-based immigration law. Lately, we've been getting a lot of inquiries about labor certification. It would seem that a lot of inaccurate information is being spread on social media by those people posing as experts, but in fact are not experts, nor are they lawyers. We are often left cleaning up the pieces, helping people to put their lives back together. Today is an informative session where we'll try to educate the community about labor certification and EB3, EB2, skilled workers, unskilled workers. And everything we say today can be verified by going to the below links at the Labor Department's website, 22 CFR 656 regulation, as well as the frequently asked questions on the Labor Department's website. So firstly, I'd like to start by describing what is labor certification. Labor certification is a process whereby a future employer offers a job to a foreign national and requests that the Labor Department certify that hiring that foreign national will not take an American's job or displace an American worker. So how does that work? How does a company go about showing that? So the first thing that a company needs to do is request the appropriate wage from the Labor Department. In other words, a physician has to be paid a physician's wage. A nurse has to be paid a nurse's wage and can't be underpaid. So the first thing to do is to get the appropriate wage by filing a prevailing wage request. The employer then looks for an American worker by advertising in the newspaper and online, posting a job notice that there's a job available, and if no qualified American wants the job, then the labor certification may be filed. At some point, the sponsor may be asked to show that they have the financial ability to pay the new worker. In other words, a company that only earns $50,000 a year can probably not sponsor a $100,000 a year employee. Likewise, the job needs to make sense. So for example, a restaurant could not file a case for a submarine pilot or an airplane pilot. So the job has to make logical sense. Likewise, a company with one employee probably could not sponsor an HR director. What is the difference between an EB3 and an EB2? We get this question a lot. So the EB3 and the EB2 refer to categories that at the USCIS that represent different skill levels. So for example, in the EB3 category includes unskilled labor, that is jobs that require less than 2 years of training or preparation. Skilled labor, that is jobs that require 2 years or more of education, training, or work experience. And professionals, jobs that require a bachelor's degree to be qualified. Also note that EB2 positions are those positions that require higher than a bachelor's degree. In other words, those are positions for individuals that have advanced degrees, like a master's degree or a PhD, or the equivalent of a master's degree, which is a bachelor's degree plus 5 years of progressive experience in a particular field. And within the EB2 category, we also have this description of people who have what we call exceptional ability, that have risen really to the top of their field. And those people who are in the EB2 category can proceed with the labor certification or without if they request that the position be approved in the U.S. national interest. In other words, a classic example of a national interest waiver, which waives the labor certification, is maybe an engineer that specializes in working on, say, condos on the beach. We recently had a tragedy in South Florida where a condominium on the beach collapsed. And so an expert in this arena would argue that his background and expertise is so essential that the U.S. ought to waive the requirement of the labor certification, which takes some time. Each category has a specific number of visas or green cards that are issued on an annual basis. For example, in the EB3 category, we have 40,000 green cards per year. Likewise, in the EB2 category, we have 40,000 green cards per year. There's a total of approximately 140,000 employment-based green cards issued every fiscal year. What is the difference between EB3 and EB2? So EB3 and EB2 refer to categories at immigration, at USCIS, nothing more. EB3 refers to unskilled labor, that is labor requiring less than 2 years of experience or education, skilled labor requiring more than 2 years of experience or education, and professionals, people who have a bachelor's degree or the equivalent. EB2, on the other hand, is for individuals who have a master's degree or higher, or the equivalent of a master's degree, which is a bachelor's plus 5 years of progressive experience. You should know also that in the EB2 category, we do have a group of individuals that are people with exceptional ability. So they don't necessarily have a particular amount of education or preparation for an occupation, but rather just they've risen to the top of their field, they're recognized, and they have an exceptional ability in some particular area. So many of those people will apply for something called a national interest waiver, which is a waiver of the labor certification process that I described earlier, where a company has to offer a job and show that there are no qualified Americans that want the job. So for an EB2 national interest waiver, the individual has to show that his or her talent is so important to the United States national interest that they should be exempt and have the labor certification waived. So you might think of perhaps an engineer that specializes in construction on the ocean front of condominiums. We recently had a tragedy in South Florida where a condominium collapsed. So an engineer who has that type of structural expertise could argue that that it's in the U.S. national interest and we really shouldn't wait for him to go through the labor certification process, which takes time, and that he ought to just be expeditiously approved for the green card because what he will do is so vital to the United States' interest. There are some other professions that are also exempt from the labor certification. Those include nurses, physical therapists, and sheep herders. Yes, you heard it, sheep herders. Don't ask me why. We've never processed one. In each category, you should know that there's a specific number of green cards issued per year. In EB3, we have 40,000. In EB2, we have 40,000. And the whole employment-based category has 140,000 every year. Sometimes there's a few more because we're allowed to recapture some other visas from the family-based sector that don't get used, but for the most part, 140,000 employment-based green cards get issued every year. So people ask, am I allowed to pay somebody to sponsor me? So the answer is certainly not. A foreign national is not allowed to pay an employer or any individual for that matter to sponsor them. Nor are they allowed to offer free labor to an employer in exchange for sponsorship. We have a question that we get quite often. I saw a live where a firm said that labor certification was fraud and that foreign nationals are not allowed to pay a lawyer to represent them in this process. So that's not true at all. EB3 and EB2 through labor certification is a totally legitimate process that has been used for many, many decades. In the United States, individuals have the right to counsel and the right to hire their own lawyer. It's sort of a fundamental right, as you might imagine. Individuals can pay a lawyer to represent them in the labor certification, in the immigrant petition, in the consular phase, or in the adjustment of status to receive the green card. Now, you may not pay for your employer's lawyer, for your sponsor's lawyer. That would be improper. Nor can you pay for the newspaper ads that are required by the Labor Department wherein the employer is searching for an American worker. You might imagine that if you're the foreigner and you're paying for those newspaper ads, that you probably could exert some undue influence over the hiring decisions. So that's a no-no. And this is what some of these so-called lawyers, who are not really lawyers at all, but they certainly do wear fine suits, that is what they hone in on. And they argue that if you're paying a lawyer, something's improper. That's not true at all. You just are not allowed to pay for the employer's lawyer, nor are you allowed to pay for the recruitment or the advertisements associated with the labor certification process, because doing so would demonstrate that you had an undue influence over the hiring decisions. Finally, we've been getting a lot of questions about this new humanitarian parole. So let me just address that, even though it's a touch-off topic. Foreign nationals from Venezuela, Cuba, Nicaragua, Haiti, and the Ukraine are allowed to apply for a parole into the United States and work in the United States for up to 2 years. Eventually, that period of stay in the United States could be converted to a green card through a process called adjustment of status if the individual has a labor certification sponsor or has a family member that would be willing to sponsor them. But what's at the heart of the humanitarian parole is the government's desire to try to reduce unlawful immigration, whereby people are coming across the border, and create a lawful process and a safe process wherein an individual can come to the United States temporarily if they're from one of these countries and can work in the United States while they're paroled in. What's required is a U.S. supporter, kind of like a sponsor, that basically promises to pay for and support the person so that they don't become a burden on the U.S. government. So that's it for today in terms of our labor certification education. But if you do have further questions, feel free to submit them, and we'd be happy to address those questions in a later recording. Thanks very much for tuning in.